come before the court is J.D A, and J.D A. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal, and if you do plan to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please come up to the podium, introduce yourself, keep your voices up, remain behind the podium. You should not use the names of children or minors or victims during your argument. You can refer to those folks as the child or initials. We have read your briefs. We're ready to proceed when you are, and I would just ask counsel for the appellant, would you like to reserve time for rebuttal?
Yes, I've reserved 5 minutes.
Very well, then we are ready to proceed when you are ready.
Thank you. Good afternoon, Your Honors. May it please the Court. I'm Alan Bedbeck. I'm here on behalf of the appellant, Christopher Anderson, father of 2 children in this case. We have raised one issue on appeal that the trial court failed, erred, and that the Children's Services did not show by clear and convincing evidence that it was in the best interest of the children, and that the decision by the trial court was against the manifest weight of the evidence. Your Honors, this is a case where there's no good outcome at the time of the trial. Mr. Anderson is a veteran who is an amputee, had mental health and sobriety issues that he was working on throughout the pendency of this case. At the start of the case, he was homeless. He addressed those issues throughout the case. He, by the end of the case, it was clear from all testimony that he was able to provide housing. He was able to meet the basic needs of the children on a financial and economic level. He maintained visitation throughout the case. He had worked on his sobriety and mental health issues. He had medications. He disputed some of his diagnoses, which is, there was no medical evidence regarding those diagnoses outside the statements of the caseworker and Mr. Anderson himself. The case seems to come down to a matter of time, that this was a 2-year time limit, which I would contend at this point has been eviscerated by decisions out of the Supreme Court, with specifically in Ray Young children. Apologize, I have to keep going back and forth. I can't see you with my glasses. I can't see my notes without these. I'll leave it to you. It's a familiar case that says that even though there's this, these sunset limitations on the jurisdiction of the court, the juvenile court retains jurisdiction to make dispositional decisions even beyond those timelines, which I don't know what jurisdiction limitation means, if not to be able to make jurisdictional dispositional decisions. So the only time when I see these timelines come into play now is in this case of permanent custody, or another point where we're saying we have to terminate the parental rights of the parents because we're just out of time. The agency, I've seen cases go on 4 or 5 years where they are still trying to work after a reversal here or some other case. There's no resolution, there's no termination of jurisdiction. Even after a case closes, they can bring back cases for further dispositional hearing without filing a new claim. The only place where this 2-year limit seems to come into relevance is when the agency says, oh, we're just out of time to pursue these cases. In this case, it's a clear example of why that is a harm. Mr. Anderson had been doing the work throughout. He is an admitted addict and would go through long periods of sobriety, 3 to 4 months, and then have a relapse. As anyone who has worked in recovery knows, relapse is a part of that recovery, and that is a thing that can happen. These were not small children. These were not young children who could not protect or self-report. The oldest child is almost 18 and will be before the end of this year. The record indicates he had a clear plan for what he was going to do and to behave as an independent adult. determination of permanent custody of the agency brought no resolution to that matter at all, outside punishing Mr. Anderson for not completing the objectives on his case plan within a timely manner. It didn't benefit that older child in any way. It didn't make any change whatsoever in his life. He had a plan, he knew what he was going to do. Mr. Anderson was involved in and took active participation in helping accomplish that plan. Mr. Anderson took active participation throughout this case, including by the caseworker's accounts, helping to make sure that the records from his VA providers were all provided to Children's Services. He was cooperative, he made all of his visits. Those visits were by all accounts appropriate. He had housing. He indicated that the heat at the time had not been on, but that was simply because it was just him and he chose to use a space heater in the home, where I believe if he had the children, he would have been able to address that readily. He had a clear idea of where his economics were, how he would be able to pay for these children and how he'd be able to take care of them. I will admit, there was a pattern of getting close to expansion and then some kind of relapse, some kind of incident would occur. There is the incident at the hospital where he busted out a window and was clearly having some kind of mental and physical concern. Is an issue, but that was an isolated incident. He was having a physical crisis by all apparent evidence, and he was polite, he was cooperative throughout even that period. I would contend, in the face of that, in the face of the fact that he was working on all of these things and wanted to be working on himself, and that these are older children who were not the same, and there was no permanency plan for these children from the side of the agency. The younger child, and I've spoken about the older child, the younger child was in an institutional adoption, an institutional facility, and had no plans. This is, to use a lay term, this was a child who was going to be put into the system with no...
The older child's almost 18 though right now.
The older child is 18 in December, yes. And that's what I'm saying is for the older child, there was literally no need to make this rule. And I would contend for the younger child, it was not in the best interest of the younger child to make this ruling. The one relative who had him, had disrupted out of that house, was not in that home any longer. He was in institutional adoption facilities and residential facilities with no prospect outside this father of a permanent home. And to allow this father further time to work on these plans and to work on this case plan, I think was the appropriate remedy. And the only thing that seems to be standing in the way of that is this claim that there was no more time to work this case plan, and that is clearly not the case in consideration of the In Re Young Children decision out of the Supreme Court. That we have this timeline that is only applied against parents at this point, and I would contend that that's an error, and that in the face of not having any other plan, there was no consideration for these children and what was going to happen to them. The only person in this case who wanted these children, who had an idea for where his sons would go, was this father. And I would contend that evidence is clear in the record, and that's against the weight of that evidence that the court found in favor of permanent custody to the agency. If there's no other questions, I'd reserve my time.
Thank you, counsel. You'll have a full 5 minutes on rebuttal.
Thank you very much.
May it please the court, Kevin DiMartino on behalf of Summit County Children's Services, the appellee in this case. We are asking that this court affirm the trial court's award of permanent custody because that decision is supported by the manifest weight of the evidence, and it is in the children's best interest. The children in this case were in their father's care after he was released from prison in 2019. This case began in March of 2022 due to concerns with regard to father being homeless. The two children at this time are 14 and 17. At the time the agency first became involved, the older child, who would have been 16 at the time, was residing with a girlfriend. The younger child, who would have been about 12, was residing in the vehicle with father. There's no dispute that father has substance abuse issues and that he has mental health issues. He testified that he's receiving treatment from the Veterans Administration for his psychotic disorder. He disputes that he has it, but he acknowledges that he has the diagnosis. Because he doesn't agree with the diagnosis, he does not take his medication. The concern here is whether or not it is in the child's best interest or the children's best interest to remain with their father or to remain in the custody of the agency. It is not a focus on what father's wishes are. There's no dispute that this father loves his children. That is a given. But the record contains ample evidence that father is not able to remedy the conditions that brought the children into the care of the agency. With regard to the,
Well, I want to make sure I understand.
Yes.
So the reason why initially the children brought into the agency was because they were homeless.
and father's mental health and substance abuse issues, which were, of course, contributing to the homelessness.
Right. But now he does have a place.
He does have a place, I don't know for how long, and the evidence was in the record with regard to his rent being, I think, around $500. I think his pension's around $2,000. He said he
And he gives blood or
get plasma, yeah, it sounded like a lot for the amount that he was acknowledging. But I don't know how long he was able to maintain that housing. I don't believe that it was sufficient. That is pretty much the testimony from the caseworker, which is he's never maintained any significant period of sobriety. So even if he gets, let's say, an apartment, there's not enough evidence that he could maintain that apartment, because when he doesn't take his medication, he has a psychotic break, or he takes methamphetamine, which is what led to that incident September 25th at Mercy Hospital. He told one of the police officers he had used methamphetamine that day. It's clear he was in some type of physical crisis, whether that was brought on by the methamphetamine or it was completely independent. I suppose it's something for a medical expert to introduce some evidence on, but he did acknowledge that he had used meth that day. And then he had this significant psychotic break. He has auditory and visual hallucinations. The children, the testimony in the record is that the children understand they can't be returned either to their abusive mother or to father. The guardian ad litem indicated that permanent custody is in the best interest of the child. So we have to look at all those factors, not just did father do one thing for one brief moment in time. That is one of the case plan objectives. That's just one piece of an important analysis that has to be made with regard to these children.
Counsel, would you address specifically the older son, since he is turning 18 in less than 2 months?
So with regard to that, we're of course looking at, the case plan up until that point, and then what we would do for a child of that age is we would be working on a permanent planned living arrangement and making efforts to assist that child in becoming independent. So the fact that he's close to 18, we still have some time to work with him to get him some basic skills so he can survive and thrive on his own. He is not going to necessarily be able to just to return to father. He knows, even though he's 17 and close to being 18, that he cannot be returned to father.
And that's what Safe Landing does, doesn't it? It helps older.
Absolutely, that is the entire purpose of Safe Landing, which I know there isn't, too much evidence in the record with regard to what Safe Landing does, but you're obviously correct with what they do, and they are a very successful agency with regard to that. The 14-year-old is in Safe Landing. They'll be working on helping that child gain those independent abilities as well. The older child, I believe, is with a relative. The children are both doing excellent in school, so this permanency plan is effective and in their best interest. They are thriving. It is unfortunate that father was not able to overcome the mental health and substance abuse issues that he clearly suffers from, but looking at the analysis under the best interest factors and going through each factor and as they apply to these two children, it is in their best interest based on their wishes, based on what the guardian ad litem testified to, based on father not remedying his substance abuse issues, relapsing in December, not submitting drug screens in May 2022, in July of 2023, the incident at Mercy Hospital where he said that he used methamphetamines, His visits have never progressed to beyond supervised visitation. So just looking at all of those factors and looking at it in the proper lens, which is what is in the best interest of these two children, the agency would submit that the manifest weight of the evidence supports that permanent custody decision awarding custody of the children to Summit County Children's Services.
Could I just ask again a couple more questions
Yes.
about J.A., who's going to be emancipated pretty soon? So he's with a relative now,
Correct.
and he has been for the length of this case.
Correct.
Now, if we affirm permanent custody, what happens to him?
So when he turns 18,
Well, I'm saying, let's say we affirm, okay, and that opinion gets out, within the 30 days, what is going to happen with him?
right, so then the agency will have a meeting and they will decide what the best course of action is for that child. I would assume, it's not in the record, I would assume that they'll work on that permanent planned living arrangement to get him the tools that he needs to be able to live on his own.
And what happens when he's 18?
They will stay in get the assistance from the agency for a period of time. I'd have to look at the statute to recall what that is off the top of my head, because I apologize, I do not recall. But they're not just gonna
He has
on
a pretty
18
good plan right now for his life.
to stay with his cousin. I don't know if the cousin will allow him to stay past 18.
Well, no, I mean, he's going to join the Ohio National Guard.
Right, he does have a good plan, that is for sure.
Sounds like, and they're both doing well in school. I just wonder about disruption.
And the major,
In his senior year and everything, that's what, and
Right.
would it be a different school, for instance?
it should not, it should stay the way that it is, the status quo with what we have right now. That is the caseworker's concern, is if we did not have permanent custody, there would be disruption. Because if we return the children to the father, he has not demonstrated the ability to stay sober or to continue with his mental health treatment, and that will for sure cause a disruption. So where the children are now, they are doing well. Everything should remain as it is until that older child can get into the services that he wishes to do. But we have to make sure we have that safety net for him. He's still very young, even though he has a very good plan, he's doing very well right now. We want to make sure we have everything in place to set him up for as much success as we can. There's nothing further as to my brief, thank you.
Thank you. Counselor, you'll have your full 5 minutes for rebuttal.
Thank you. I would address a couple of things that the Appalachian Council stated. First, she mentioned a PPLA plan, permanent planned living arrangement. For the older child, I think that is what should have been filed in the first place. I think that's where this case should have been. If that was the alternative, the least restrictive option available for that older child. Unfortunately, some years ago, the legislation in its wisdom changed the rule so that that was not available for children. It used to be at the age of 13 that was available and would have been available for both of these children. Certainly for the older child in this case, to now suggest that that's what they're going to pursue after the fact, after terminating these good parental rights for this father, is almost offensive to suggest that that is the path that's going to be taken, knowing that that was the outcome that could be reached. Unfortunately, I think the case law is such that only an agency can move for that PPLA.
Aren't we just talking in speculation here right now?
I don't think we are, actually. I think that it's really clear that this should have been a PPLA case. And I think that the statements of the prosecutor here make that really clear, that that is the outcome that's going to be in place. Either we should have let this get out till this child reached 18 and went into the National Guard, which he said was starting over this past summer at the age of 17, not speculatively and in the future. The record indicates that he was starting that this summer of 24 in the trial record. But he's already moved on and out of this home, and probably in that position now. So we've done nothing but terminate this father's parental rights for this older child for no reason, for no gain. There's no benefit to this child at all from that.
Well, it sounds like from the onset of the case, he wasn't even residing with
Yes,
Because it sounds like he was not living in the automobile with,
two children that I did not reside with me, that I still have custody, that are still my children at this point. You know, I mean, that's a difference, okay? And again, at the start of this case, my client was unhoused, was living in a car with a younger child, and this older child was staying with the girlfriend. That's not in dispute, okay? He took actions to remedy those things. He took more than one action at one time. I think the record also indicates that he knew what his rent was, he knew what his utilities were, he knew how he was gonna be able to pay those. He articulated that in the transcript and in the record. When you read through that, you will see that he stated he had $400 worth of rent, $418 rent, $30 of gas payments, $80 budget on electricity. So he knew what those utilities were gonna be, and he knew that he could make those. And he had been in that house for some period of time. And that was even throughout this period of disruption, where he had these relapse incidents and went back into IOP. And I would also state that I think the children stated that their wishes were to return to father. They didn't want those parental rights terminated. So in terms of children's wishes, that is another factor in favor of not granting this permanent custody. And I would contend that the prosecutor stated that the younger child was thriving. The younger child had run away from the home, was engaged in disruptive behavior. The younger child was not in an ideal situation at this time. He was not benefiting from this agency placement in custody at that time. He was in a disrupted situation. He was in residential institutional housing. He was not, as the prosecutor would represent, thriving. So I would again state, I believe that the manifest weight of the evidence in this case weighs against granting permanent custody, and there should have been more opportunity for this father to have these children in his home or return to his custody. With that, I would rest on my brief if there are no other questions.
I do have a question. It's unclear to me what the GAL's, the children's wishes are, because even the journal entry says that children understand they can't go back to dad, and then, so then they are saying they want to be with their current placements. So I guess I don't understand
And I
what
would
their actual wishes are.
read that transcript with what the GAL has to say. I think
Do
that
you know what the GAL, that's what I'm asking you.
the GAL's position, I don't dispute that the GAL was in favor of permanent custody. I think he struggled with that, but that's where he was.
I'm talking about the child's wishes.
And
What was the testimony? Because I'm getting conflicting things from the both of you on that.
And I
And the journal entry.
cannot recall it. I do know that, I mean, at least father's lawyer's representation were that the children wanted to go home. So, and I cannot recall the GAL's representations at this time. Okay,
Thank you, counsel.
thank you. Nothing else? Thank you very much.
Thank you. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of that decision to you on the day